The former federal prosecutor, now the great defense attorney, and he is on London radio, on Fox News Channel, on local channels in New York. He's on Fox 5 in New York, on their morning show in Los Angeles. And he's so good to give us a little bit of his time. He such a great mind on the law. David Katz, everyone. Hi, David.
Great to be with you guys.
David, what about this idea somehow that Kim, we'll start with Kim's question. Kim, you want to jump back on and you can ask David about this, the limits of speech on campuses and the scourge of anti-Semitism as it's played out. There's an actual, and you'll appreciate this, David, didn't you go to Berkeley?
I did.
Berkeley Law.
Yeah. There's college too.
And there's a lawsuit being brought now against Berkeley for anti-Semitism, for alleged long-standing, unchecked spread of anti-Semitism at the school at UC Berkeley.
People can say vile things and hateful things and awful things, and that's allowed in America because you can say things, but until it rises to the level of a crime or it crosses over into some type of physical violence or physical harm, then we've got a problem. But how do you balance the need for people to feel safe, especially right now, Jewish students who don't feel safe on campuses versus the right for people to get out there and protest and say what they feel they need to say?
Well, legally, Kim, you can't make an actual threat. And you also can't do certain things. There are limitations on your First Amendment rights. Everyone knows you can't scream fire in a crowded theater. Well, you can't, disrupt a meeting or disrupt a class in a way that, by threatening violence, by hitting the fire alarm, you can't, there's fighting words. You can't issue fighting words. And in some instances, these may amount to fighting words, these things where they start screaming at each other, and it may constitute fighting words to the point that you almost have self-defense. Of course, in my opinion, you should always retreat. You should always try to find some way where you don't actually get into any kind of a physical fight. That just doesn't make sense. The Berkeley lawsuit, my understanding is a lot of it is over discovery and records. They want records of internal emails and things like that, which they claim that Berkeley has stonewalled. So their case starts with getting the discovery. Berkeley says there's thousands of emails that have to do with our policy toward these allegedly anti-Semitic demonstrations that have been allowed to go on. And the response by the plaintiffs is, really, there's thousands of emails and that's why it's burdensome for you to produce them? If there's thousands of emails, that's part of our narrative.
Sure.
We want those thousands of emails. What people are writing thousands of emails to condone or be apologists for these anti-Semitic demonstrations. But generally, my feeling is that, no snowflakes. People are old enough to, volunteer for the military. They're old enough to vote. They're old enough to sustain a heated conversation on both sides. And the idea of being a snowflake, I always laugh about it when they say Berkeley students are snowflakes. They say, well, Republican candidates are snowflakes. You're in that. You mentioned Teddy Roosevelt before, right? There's a lot of things to not like about Teddy Roosevelt, but this idea of a vigorous discourse, the idea of a debate, including a debate that can get heated and looking at both sides of the question, that's the idea, of a liberal, small L, liberal education, of seeing both sides of it, of arguing both sides. One of the things that I loved about moot court and law school was you show up with these positions all mapped out and you're going to say this and say that. And the best moot court is that 10 minutes before the argument, they say, okay, argue the other side. And it seems that's part of being an advocate. That's part of being an attorney. This idea, you see people come on TV and there's a chyron at the bottom that says, practice restricted to the innocent, only defends victims. First of all, how do you know somebody's a victim before you start out and fully, that's for the jury to decide, right, whether somebody's a victim or not. And so all of this sort of, to me, there's an awful lot of posturing, an awful lot of that goes on. Having said all of that, I've read Dean Chemerinsky's editorial, who said, I am the biggest advocate of free speech ever. And yet what I've seen at Berkeley and some of these other campuses like Cornell, some of the other ones, it's just too much already. I mean, people just screaming at you are obviously fighting words, calling you all kinds of names. That is not furthering the debate. Calling people all kinds of slurs and names. So I haven't really answered your question, but those are my thoughts, Mark.
Well, no, that's actually interesting. And Chemerinsky, I'll remind everybody, is the dean of the law school at Berkeley. The idea then, though, in your last comment there, that when you get to slinging enough of this, you're saying, even Chemerinsky is saying, well, that's not furthering speech, and there should be some kind of, it sounds like he's saying not there shouldn't be a legal limit, but there could be a campus policy on it. Is that what he's saying?
Well, I think there are right now campus policies. And one of the things is to avoid these snowflake arguments so that there are these safe zones. Some of the schools have resegregated. It just seems to me that resegregation along racial, ethnic, political lines is not healthy. And I know that there's all kinds of natural tendencies. I said to someone I know who went to Berkeley, and is a very distinguished lawyer, she just won an award here. I said, so what was it like you in undergrad, you at one of those fancy Ivy League schools? And she said it was great. The education we got was great, but we Black students pretty much stuck together. Maybe that was the era, maybe that was us, but we were not an integrated class in college. We were in law school. And it just seems to me that, I'm a huge idealist. Everyone should get along. Everyone should enjoy the diversity. They should, to have a diverse campus, but that in fact is sort of resegregated along any kind of lines is unfortunate. I know that those things happen. So,
yeah, it's funny. I also think that these diverse communities, it might be a college campus, it might just be a dining room table. It might be a table at Starbucks or whatever. I think the more diversity in your life, it enriches the experience so much, So I share, and at the same time, that notion in my head coexists with this awful fact, which is that we're tribal. As a species, we are tribal. And so the tribalism goes from family to neighborhood to skin color to religion. We have all these ways to divide our different tribes. Even you can look at about the Muslims. It's not all Muslims. There's Shiite Muslims. There's the Sunnis. Within Christianity, there the Protestants. Within Judaism, they're the Hasidic Jews. It's a very bizarre fact, I suspect, as I come around to every year realizing that we are just tribal, and our attempts to stamp out the tribalism just are ill-fated.
Mark, can I just say one thing? I was a student of foreign languages, among other things, and I'm quite bilingual in Spanish, and I wanted my Spanish to be really excellent, especially when I was an undergrad. So I went to Spain. I'd studied in Mexico while I was in high school. I did one of these years, a summer abroad in Mexico, 1968, just before the Olympics. And it was with the Friends of Mexico. President Obama sent one of his daughters to the same program years later. And it was a wonderful total immersion into Spanish. And then during college at Berkeley, I went and spent a summer in Spain. But because of that interest in a foreign language, I met a lot of people from different cultures. I met a lot of people who are Catholics. My friends always make fun of me because part of learning Spanish, you learn all the parts of the church. You meet all these Jesuits. I learned some Latin. A Jesuit priest said to me in Franco era Spain, he said, this is what's happened to the world today. The only people who know Latin are the Jews. I thought that was pretty funny. Solamente los judíos hablan latín, estudian latín. So, I just recommend to people to do whatever they can to try to really have a diverse experience. Learn a foreign language, learn a foreign culture. I think that really does increase it's so easy for us to sort of stay home. I saw a scholar the other day who had learned Mandarin Chinese. And someone said, my God, at your age, how do you possibly learn Mandarin Chinese? He said, I just turned off the NFL. The time I used to watch NFL football, I learned Mandarin Chinese, spoken and written. So
let me tell you, just last night at the dining room table, we were discussing what the most difficult language to learn is. And I maintain it's Chinese, because every character, if you just go up in inflection at the end of the character, it totally changes the word's meaning. So it's very funny that you mentioned Mandarin, because I view that as an unbreakable code if you're an adult. I mean, if you're a child, you can learn, your mind is built that way. Your brain is built to absorb languages. But as an adult, I get mad respect. And the fact that the NFL stole so much time from that guy's life that by giving it up, he was able to do it is remarkable. Because you speak Spanish, I'm going to ask you to translate my predicament as I go to Ecuador, Guatemala, Chile, and Peru beginning tomorrow. Puedo hablar, pero no entiendo nada. Tell everyone what I just said.
You speak, but you don't understand everything.
That's exactly
right. Mark, with your excellent pronunciation, which you just showed in pronouncing the countries correctly, and because you have this great voice and you speak so well, people are going to think that you understand everything because if you can speak as well as you do, so they're going to start say despacio.
Yes, despacio, por favor. Yeah.
Más lento, despacio, and
Más
maybe
lento.
You'll have luck that people will slow down to a pace that you'll grasp
manageable.
what they're saying.
All right.
A lot of things are translated, and of course, a lot of people speak English, especially if you're in a tourist place.
Sure.
That's
I'd like to mejorar my Spanish. I'd like to improve my Spanish, but I'm we'll see. Now
you may get one Spanish language credit just for watching the program today, Mark.
Okay, now let's talk about Senor Rudy Giuliani. Okay, he skipped out on this court hearing yesterday. This is ahead of his defamation trial, so the judge was angry about that. Can you speak to the realities of the repercussions of doing something like that if you're Giuliani?
Well, if you defy a court's order in a criminal case, you're very likely to have your bond revoked and find yourself not out on bail, but awaiting a criminal trial in custody. So one of the things as a white-collar criminal defense attorney, I'm always admonishing my clients to be very, very careful and, of course, strictly obey all the court orders. And if you have any issue about whether you should be there or not, because sometimes your lawyer can appear for you. But if you have any issue about whether you're complying with the court order, make sure that you're complying. In a civil case, if you don't show up for a deposition, they can comment on that. They can use that against you in the civil case. But I'm not entirely familiar with Giuliani's situation because I've been preparing on Purdue Pharma.
Yeah, we're going to get to that. We're going to. This just crossed, so I wanted to it doesn't look like there are going to be any real repercussions. The attorneys for Giuliani were yelled at by the judge, but it does. But so this is again the defamation trial. So we'll see. But again, Howell, who was the judge in this case, I believe, has already ruled that Giuliani is civilly liable on the plaintiff's defamation, and so we'll see how this all plays out. But that was his latest bit of brinksmanship, was to not show up for this pre-trial. He didn't want to confront his accusers, apparently, and the judge was irritated, but it doesn't look like there are any other repercussions. And as you say, since it's not a criminal trial, I guess he gets away with it.
You can be held in contempt even in a civil case. If in the middle of your civil case you just start insulting the judge, swearing at the judge, something like that, you would be in criminal contempt because you did something in a courtroom, civil or criminal. But I can't go much more into depth into Giuliani's case. Before we get into the pharma case, can I just say, because I haven't had a chance on your show to acknowledge Sandra Day O'Connor, and she truly was a giant. I mean, she was a trailblazer. And I've been working for years with another attorney who actually was her law clerk under very interesting circumstances. He was either the first or very near the first. And if I can just tell the story for a minute in honor of the truly great Sandra Day O'Connor. She was picked about a year into President Reagan's term. And her ascension to the U.S. Supreme Court was made possible by the resignation of a judge named Potter Stewart, who was one of these old guard. You don't hear his name very often, but he was one of those truly conservative, in the best sense of the word, follow precedent, always, interested in his take on a case because it was always so thoughtful. And this very thoughtful, conservative in the best sense judge resigned, and that made possible Sandra Day O'Connor going on the court. And the Washington Post said at the time, it's very dated, but that Potter Stewart was such a gentleman, he gave up his seat for a lady. That was considered very clever. I know, very dated by now. And the whole country was fascinated. And one of the fascinated people was my best friend, who was going to be the law clerk selected by Potter Stewart. Was he then going to be selected by Sandra Day O'Connor? She didn't have to keep Potter Stewart's law clerks. They'd been selected by him. Well, anyway, it had a very happy ending for the country. We had Sandra Day O'Connor. She was confirmed, and she kept my friend as one of her very first law clerks. The law clerkship is for a year. And of course, she became a real trailblazer. And I mean, I don't need to tell you or Kim especially, but was a huge example for women to follow in her footsteps, to become lawyers, to become judges. Now it's so normal to have women on the Supreme Court, women on the state Supreme Courts around the country, women in very high positions, prominent positions. But it was a thing then, and she really was a trailblazer. Her famous decision in Casey versus Planned Parenthood, 5-4, she cast a decisive vote to keep Roe v. Wade alive. It turned out only for another 20 years, but to keep it alive at the time, and it seemed like it was very much. And then the people who don't think that she was so great do remember her casting the 5th vote in Bush v. Gore. And I always thought she should have known better, and she should have stayed out of that one. But she did cast the 5th vote that allowed that stopped the count, and that crowned Bush. As people said, Bush won the only vote that mattered in 2000, the 5-4 vote of the U.S. Supreme Court, and that was her decisive vote for Bush in that one. But I think her whole legacy was really terrific. And you look at what the Supreme Court's done since, and she was just really one of the great ones. So I wanted to give that shout out, and then on to the Pharma case, if we can.
Yeah, I mean, that's so well cast, the history of Sandra Day O'Connor in every way, the controversial way and also the historic way. So let's get into this Purdue Pharma thing. There is a deal struck, and now that deal could be in question?
I think, what am I, 17-0? So this may be 17-1, because I am really struggling. Yeah. I'm really struggling to figure out how this case is going to come out. Not how it should come out, not how I want it to come out, which I'm not entirely sure of. There's an editorial, by the way, in today's LA Times, which is worth reading if people want to see it. It's called, "Has the Sackler Family That Gave Us the Opioid Crisis Suffered Enough?" Well, if you look at it that way, no, they haven't suffered enough. They haven't paid enough. But they're willing to pay $6 billion. And so the Supreme Court is really wrestling with the fact that if they undo this settlement, the Sacklers will fight this like hell, which they've been doing for over a decade. And this is not whether they go to jail or not. The Sacklers are not going to jail, no matter what their role was, no matter how awful it was in this opioid crisis, and how much families and communities have had to suffer with this opioid crisis. That's not what the issue is. The issue is it's a little complicated, and I think Kagan on the Supreme Court kind of summed it up. But if you step back from it, there was no criminal prosecution. This all happened about 2007, 2008, and only the company was prosecuted, or a holding company for the Purdue Pharma was ever prosecuted in this case. And then these civil lawsuits started against the Sackler family. They're supposed to be worth billions and billions of dollars. And so one view of it, and this is the view that the liberal states took, Mark, was that they should be sued until the cows come home. They should be sued forever. Full accountability means full accountability. And if your family's worth $12 or $14 billion and you only bring $6 billion to the table, how is that full accountability? But the other side of it is they brought $6 billion to the table. And these cities need it, and these Native American tribes need it, and the individuals need it. And 97% of the people, supposedly, who are interested in it think it's okay. 3% don't think it's okay. And the 3% who don't think it's okay are the ones that are saying, look, the Sacklers still have money, and we want to go after them. Who's to say we're not going to get more money when we go after them? But the Supreme Court is thinking, if this whole thing comes asunder, and in the name of principle, we throw out all of this money, And it doesn't work out according to principle. The Sacklers fight and fight and fight, and these communities that want the money, these individuals that have fought so hard for the money, these Native American tribes, suppose they get bupkas, suppose they get 1 billion and not 6. They don't end up getting the 10 or 12. They don't get the 6, and they don't even get a less than 6.
It is a roll of the dice. Yeah, and so again, just to remind everyone, and again, just to reiterate, it's a deal that was made. The Sackler family, as you suggested, wildly wealthy, said, we'll break off, was the number $6 billion? Yes, $6 billion. And that will address the opioid crisis that we helped create, or whatever. I don't know if they put in the we helped create part. And will also have nothing to do with the company anymore. Isn't that right, David? I think they divested themselves from Purdue. So
from the point of view of the plaintiffs and the conservative states that pushed for this settlement, and they line up Democratic, Republican, they line up the conservative states, accepted it pretty much not from the outset. Like I said, the Sacklers fought for years and years to not pay a penny and to fight every one of these civil lawsuits. But the conservative states were the ones that first went for it, and then Massachusetts, New York, California kept fighting, saying, throw in more, throw in more. I don't get through all the details, but eventually
that allowed them to then now no longer have any liability. That's the point. We're giving you this money. We admit to it. We'll have nothing more to do with the company. Now take this money and use it in your communities and rebuild them for the damage done by the opioid crisis. And you're suggesting that there's a small percentage of people, and now this is my question, when you say the 3% feel like, hey, no, there's more money here and they ought to pay more, they did more damage than $6 billion. How much of that is driven by the legal profession in this, and how much of this is done by, grievance that can be called more legitimate?
A lot of it is the plaintiff's bar, but it's not easy to win these cases. I had a case against the Los Angeles Police Department. We ended up winning almost $2 million. It was so much work. It was such a hassle. You don't really make that much per hour as people think when you add up the whole number of hours, the experts you pay, the Medicaid payment that you have to make. But we won. And even having won, I just decided that unless I saw a case with that great facts again, I wasn't that interested in being a plaintiff's lawyer myself, even though I had a case and I won. And I admire these folks, men and women who take these cases. But yes, they take them on a contingency. And yes, it would be a disaster for the lawyers who put the money in and the experts who put the money in, because they would lose their 1/3 or 40% recovery. It would also be bad for their clients who are getting the 60 or 67% of that money. Yes, the plaintiff's lawyers are getting 33%. And then you have all of these cities, and the cities are trying to deal with the aftermath of the opioid crisis. They're trying to, have centers, they're trying to do treatment, they're trying to do all that. And the cities would be out the money unless they figure out a way to get the money from somewhere else. Now, you could say, well, why doesn't the government just say, you know what, we'll pay that money. We'll pay some billions of dollars. Throw it out, which is what the government says. I mean, it's admirable of the Biden administration, because the Second Circuit Court of Appeals ruled in favor of this settlement. And there was nobody to protest it, really, who had standing except the U.S. trustee. The U.S. trustee in bankruptcy has a duty, Mark, to make sure that the bankruptcy process is fair. And they took it to the Supreme Court, and they got the Supreme Court to take cert on the case. This one turns out to not be that ideological. And people like Justice Kagan are trying to figure out what she wants to do. There's also a block of the court. I think Amy Coney Barrett she's one of them. She likens this case to the Boy Scouts and the Catholic Church, because the Boy Scouts and the Catholic Church have made deals like this too. We're putting this much money on the table, and then we're going to go back to being the Catholic Church, and we're going to go back to being the Boy Scouts, and you're going to not sue us anymore, and you're going to not sue individuals anymore. And the anomaly of all of this, Mark, is that this is being done through the bankruptcy courts. This is because Purdue Pharma went to the bankruptcy court and they said, okay, here's our reorganization plan. This family, the Sacklers, are going to get out of it. We're going to have this turnaround expert in charge of it. We're going to become a good organization. We're going to just do good things. We're not going to sell opioids anymore, they said. And we're going to have the Sackler family throw, at that time, $4 billion on the table. Ultimately, with all the problems, all the people screaming, they threw $6 billion on the table, and that was the final settlement. The Sacklers themselves, Mark, never went to bankruptcy court. They are not themselves bankrupt. If they're worth $10 billion, they're worth $10 billion. And if this settlement stands, nobody can sue them. That's why it sort of violates principle. It's money against principle. But the money is so strong because there's going to be $6 billion to pay victims. And yes, some of it's going to go to lawyers, but there's going to be the overwhelming amount of it to pay victims and to do, remediation. And so do you throw out the baby with the bathwater? And then, for instance, Justice Alito said, well, you can't really get this money out of him anyway because they sent so much of it offshore, and it's sitting offshore in the name of the individual Sacklers or people in trust for them, in spendthrift trusts. I mean, Mark, I can never believe Alito when he wants to go in a certain direction. Suddenly, there's all these problems in the world. If this was some cartel guy, and the argument was, well, don't get any more money out of the cartel guy because the money it's offshore and it's in a spendthrift trust. They would say prosecute him to the end of the earth, wouldn't they? I mean, civilly prosecute him to the end of the earth. Make sure the guy doesn't get a passport. Make it difficult for him to travel into the United States. Take it into a civil court, Mark, and have the judge there order that person to break that spendthrift trust and to spend the money back. They've done that with money offshore, Mark, and they have the person held in contempt, in civil contempt, and they say, you're going to jail until you pay that money, right? That's my order. You're not a criminal, but my order is that you break that spendthrift trust and you send $1 billion back into the country. The guy says, I'm not going to do it. They say, well, until you do it, you have the keys to the jailhouse door in your hand, but you're going to jail until you do my order. That's been done over and over again. But suddenly that can't be done with these folks. Having said all of that, all of those principled things, I think on balance, because you have Amy Coney Barrett, I think, is going to vote for the settlement. Kavanaugh, from his question, said 97% are for this because it gets them prompt payment. You've been doing this for 30 years. But the fact that they've been doing this for 30 years, Mark, doesn't change the fact that it is a blueprint to get away with massive fraud. There is no reason why anyone who commits a mass tort wouldn't try to set this thing up. You get nothing from the individuals who did the mass tort. You did nothing from the environmental polluters. You could even think of someone like Trump. Wouldn't Trump love this deal? He probably called his lawyers and said, how come you idiots aren't like Roy Cohn? How come you idiots haven't thought of this? This one and that one, they'll go bankrupt. And the agreement will be that Trump will not be sued by anybody civilly because, the Trump organization, this one, that one, they went bankrupt. They put $1 billion on the table for whatever remediation is that you guys want. And then Trump is never in bankruptcy. Like the Sacklers are never in bankruptcy. So, Mark, they haven't inquired of them, how much are you worth? They can't even take their deposition in bankruptcy court and say, how much are you worth? If you're really worth only another $1 billion, maybe $6 billion makes sense. Suppose you're worth another $20 billion. You're worth $20 billion. Maybe the documents would have shown if they'd individually gone into bankruptcy, they have $20 billion. No, 6 doesn't make much sense, does it, if the Sackler family walked away with $20 billion? But we don't know that because they themselves are never in bankruptcy. So the principled argument is, how do you get the benefit of the bankruptcy order if you yourself are never in bankruptcy? This is like a third-party windfall to the person who caused the opioid damage in the first place.
This
what
is
a tough case.
Yeah, very tough one.
Remarkable. There's lots of dead people involved who were memorialized in the placards outside of the U.S. Supreme Court. My son would have liked to know his father, placards. So
what is Katz's final position on this case? We only have 30 seconds. Go ahead.
They will affirm it, and they will issue strict rules to make sure this kind of thing doesn't happen again. They'll say that the bankruptcy judges and other judges should scrutinize it very carefully. They'll limit it in certain ways. If the only thing that would make the deal fly was, let's say, getting somebody out of jail, if you give the person civil liability, and oh, by the way, they don't get prosecuted at all, that's the deal that, let's say, Trump would want, that's too far. That's too far. But the statute had already run because they didn't murder anybody, no matter what your view of it is, and it's awful what happened, in my view, but they didn't murder anybody. So the statute of limitations has run, Mark, criminally. But if you wanted to stop the statute of limitations on somebody, that would be too far. But in certain circumstances, apparently, yes, these mass tort feasors can do something like what the Sackler family did, and the Sackler family or people like them in the future can walk away with a big chunk of change, never be scrutinized in the bankruptcy court. Yeah. You throw out the $6 billion. You're on the court, Mark. You throw out the $6 billion.
I throw it out. Yes, I throw it out. Absolutely. Okay. It's a horrible precedent. absolutely horrible precedent for all the reasons you've articulated. There is Katz as illustrated by one of our viewers. And David, love you. Un placer. Mucho gusto en verte otra vez. You know, a lot of fun seeing you again.
El gusto es mío. Que te vaya bien en Sudamérica.
Oh, well done, well done. He says the pleasure is mine, and have a good trip in South America. Bye-bye, David Katz. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.